has pointed out require constitutional amendment and also presented a roadmap for the reform process. As Laz, we have sat down and studied the said paper, and in line with our statutory mandate, would like to offer a detailed response to that position. Before I go to the specific issues that the minister announced, there's also another issue which happened this week, which was the announcement and advertisement of 20 positions for the position of superior judges that government announced through the Judicial Service Commission. I want to begin by commending government for that stance, which is very important in enhancing transparency in appointments to judicial officers. So we commend government and the Judicial Service Commission for that particular gesture. We would only urge that that process must in fact be legislated so that appointments to the office of a judge in this country is given the assured transparency and accountability to members of the public. So it is not good enough that through the goodness of the Judicial Service Commission and the government, we have resulted with advertisements being done. We think that there must be a clear legislative process that protects that process. That said, let me come back to the issue of the outline that was presented by the Minister of Justice and our position to that outline. The first issue the Minister of Justice presented is the issue of delimitation of new constituencies and wards by the Electoral Commission of Zambia. She did highlight that under Chapter 1 of the laws of Zambia, the Constitution has provided and fixed a number of constituencies in that particular law, which is our Constitution, and the current number is 156. Under the said Constitution, the Electoral Commission of Zambia is mandated at intervals of not more than 10 years to review the names and boundaries of constituencies. The Minister indicated that it is proposed that Article 56 and 68 of the Constitution be amended to provide for actualization of delimitation of constituencies and wards to be determined by the Electoral Commission of Zambia. The impact of delimitation, according to the Minister, is to provide for equitable distribution of resources, particularly the CDF, based on population and geographical size or landmass. Equity versus equality, she stressed, and gave an example of huge constituencies which are big in size and as big as some European countries, getting the same amount as small constituencies. She believes this is injustice and inequity, and that the people of Zambia must be concerned. Our response to this is that indeed we acknowledge that this is a new proposal. However, delimitation requires a careful and wide consultative process to avoid potential political conflict in terms of drawing boundaries to perpetuate political gains. Proposed timeline in the roadmap is not sufficient to achieve the required consultative process, and rushing delimitation ahead of elections is not wise. There is also no agreement as to the basis of the proposed delimitation exercise. Will it be based on the 2019 review by the Electoral Commission, or indeed will it be based on a new exercise? have political parties agreed the parameters of the proposed delimitation? And will they agree just before elections? Using the argument of CDF as a basis for delimitation is also not persuasive, as CDF is not in the Constitution. CDF, you will note, is not one of the matters to be taken into account by the Electoral Commission of Zambia when delimiting constituencies and wards under Article 59 of the Constitution. In any event, there are many options available to the government to enhance equity in CDF allocations and utilization. Government could consider allocating CDF based on the number of wards within each constituency. Considering that creation of wards does not require constitutional amendment, but is within the control of Parliament, bigger constituencies in terms of geographical size and population can have more wards, thereby attracting higher CDF to achieve the much intended equity in the interim. Government could also consider creating more districts to enhance service delivery in areas with bigger constituencies in line with the decentralization policy. Additionally, government should attend to the inefficiencies surrounding the low utilization of CDF across the country. For this reason, we do not believe that the proposal to amend the aforementioned articles is urgent. The second issue was the need to revise the provisions relating to filing of fresh nominations on resignation of a candidate in an election. The minister highlighted that under Article 52(6), the ECZ is mandated to cancel an election and require the filing of fresh nominations where a candidate resigns. The proposal is to amend the aspect relating to the resignation of a candidate as opposed to requiring the filing of fresh nominations, so that the remaining candidates can proceed to participate in the election. This, the minister indicates, is an unnecessary cost to the government and would have the possibility of destabilizing the peace of our country. Laz's response to this is that, in fact, this proposal is what was contained in Clause 11 of the Bill 10 of 2019, which ultimately failed to pass. The proposal, in any event, requires wider consultations and consensus with stakeholders, including political parties who sponsor the candidates. It can therefore not be stated to be a non-contentious clause. The third proposal is the introduction of an electoral system that enhances representation of women, youth, and persons with disabilities in the National Assembly. It was submitted by the minister that the current electoral system does not provide guaranteed seats for women, youths, and persons with disabilities in the National Assembly. Therefore, the minister submitted, it was proposed that the Constitution under Article 47(2) and 68 be amended so as to guarantee the representation of women, youths, and persons with disabilities in Parliament. Our response as Laz is that this indeed is a progressive proposal, considering the low participation of women, youths, and persons with disabilities in the National Assembly and in key governance institutions in the country. However, there are existing constitutional provisions to address this challenge. Firstly, government should fully implement the provisions of Article 60 of the Constitution by urgently enacting a political parties bill, which should compel political parties to adopt more women, youths, and persons with disabilities as candidates in parliamentary elections. Additionally, government should take advantage of the provisions of Article 259 of the Constitution, which calls upon appointing authorities to appoint women, youth, and persons with disabilities into key governance institutions. We note that this proposal is also similar to what was contained in Clause 15 of Bill 10, 2019, which ultimately failed to pass. In any event, it should be part of the holistic constitutional reform process. Number 4, reintroduction of members of parliament in councils. The proposal here is to amend Article 153(2) because the current article does not include members of parliament as being part of their respective councils. Our response is that this proposal is similar to what was contained in Clause 52 of Bill 10 of 2019. The proposal requires wider consultations and consensus with stakeholders, including political parties. It must be part of a holistic reform of the Constitution. Number 5 is a proposal to provide for the hearing and determination of an election petition. According to the Minister, she points to the provisions of Article 73(2), 1015, and 1032 that provides that a parliamentary election petition and a presidential election petition shall be heard within 90 days and 14 days of the filing of the petition, respectively. The proposal is that these provisions be amended to clarify that the specified time frame for the petition should include heard but also determined within those time frames. This, she submits, will avert the unfortunate position the country found itself in 2016. Our response as Laz is that this, again, is exactly what was intended to be cured by Clause 30 of Bill 10 of 2019. Additionally, we note that there are a number of statutory instruments, specifically the Constitutional Court rules, statutory instrument number 37 of 2016, as amended by statutory instrument number 29 of 2021, which have greatly brought clarity in determination of election petitions, including a presidential election petition, to avoid the repeat of the unfortunate position the country found itself in 2016. There is nothing to be cured this far. Number 6 is to revise the provisions relating to by-election. The proposal is that, considering that under Article 57(1), which provides that a by-election must be held in the event of a vacancy in the office of a member of parliament, mayor, council, chairperson, or councillor, the proposal is to ensure that for any of these positions where the candidate was sponsored by political parties, we must dispense with the holding of those by-election. The reason is that, in fact, the country is spending colossal sums of money, both the country to run the by-election, but also the candidates are subjected to huge colossal amounts on this process. We have bridges to build, we have schools to run, the minister indicated, and therefore Article 57 be amended so as to dispense with holding of by-election where the vacancy is on account of a member of parliament or mayor under a political party. Our position as Laz is that this is new and indeed progressive insofar as it seeks to provide a solution to the colossal sums of money spent on by-elections. However, the proposal requires wider consultations and consensus with stakeholders, including political parties. While the problem of by-election is generally agreed, there is no consensus on the solution. Whatever the solution will be or should be, it is important to balance the rights of citizens to vote for candidates of their choice, both in the initial election as well as in by-election and dispensing with by-elections. It must be, therefore, part of the holistic reform of the Constitution and not treated as a non-contentious issue that must be rushed into a reform process. Number 7 is the increase in the number of nominated members of parliament under the Constitution, considering that 682 provides that there shall be not more than 8 nominated members of parliament. It is proposed that Article 68(2) be amended so as to increase the number of nominated members of parliament to a number that would be provided in an act of parliament. Our response to this proposal as Laz is that this is a contentious and in fact retrogressive proposal. It will result in increasing instead of reducing the powers of the presidency. The proposed article can be subject of abuse with the potential to water down the accountability and legislative function of the legislature. It may result in creating a rubber-stamp National Assembly for the executive's arbitrary actions. The executive arm of government will effectively do whatever it shall please, including passing legal and constitutional amendments it may desire to the detriment of the democratic practices. Ultimately, the citizens will be the ultimate losers. We also note that one of the reasons behind the nominated members of parliament under Article 68(2) is to allow the presidency to incorporate youths, women, and persons with disabilities, or indeed citizens with unique skills and experiences, into the National Assembly and Cabinet. It would follow, therefore, that if we are discussing broadening pathways for women, youths, and persons with disabilities into governance institutions, at the bare minimum, we must be maintaining the status quo of not more than 8 nominated MPs, and not the possibility of increasing. If the president wants more people to be appointed as cabinet ministers, then perhaps he should be proposing appointment of cabinet ministers outside parliament, as submitted by various constitutional review commissions, and not bloating the legislature. It is also unclear which stakeholders recommended the relegation of the number of nominated MPs to an act of parliament, considering that the issue has been extensively debated at previous constitutional review commissions, and it has been agreed that it is safer that this limit on nominated MPs be in the Constitution. It is Laz's position that this proposal poses the most threat to the national values and principles of democracy and constitutionalism, good governance and integrity, as contained in Article 8 of the Constitution. Nothing stops Parliament from prescribing that the number of nominated MPs must be equal to the number of the elected MPs. That will be within the powers of Parliament. Unfortunately, such a situation would mean the end of democracy in this country as we know it. Number 8, harmonization of the term of office for members of Parliament. It is submitted that under Article 181, which provides that the term of Parliament shall be 5 years, starting from the date that the member of Parliament are sworn into office after a general election and ending on the date that Parliament is dissolved. This, according to the Minister, translates to a period of only 4 years and some months. You will note, she indicates, that Article 266 of the Constitution has a similar definition for the word term. It is therefore proposed by government that Articles 81 and 266 be amended in order to actualize the term of office for MPs to a period of 5 years. Laz's response: this proposal is exactly or similar to what was contained in Clause 22 of the ill-fated Bill 10 of 2019. It is also hard to appreciate the real mischief that it is intended or aimed to cure. The dissolution of Parliament 90 days before the holding of general elections under Article 181(3) of the Constitution is aimed at reducing the potential for abuse of public funds ahead of elections. It also ensures a level playing field for all political players so that members of Parliament and cabinet ministers from the ruling party do not campaign using the public purse. In any event, we don't see agency for the recommended proposal. It can benefit from a holistic reform of the Constitution. Number 9, vacancy in the minister's office 90 days before elections. Under this proposal, the minister highlights that under Article 116(3), the Constitution provides for vacancy in the office of the minister. It is proposed that Article 116 be amended to provide that the office of the minister becomes vacant 90 days before the holding of the next general elections. This, the minister indicates, shall avoid the illegal stay of ministers in office and use of public resources for campaign purposes. This, again, according to the minister, is in line with the decision of the Constitutional Court judgment as stated in the case of Stephen Katuka suing as Secretary General of the UPND and the Law Association of Zambia versus the Attorney General and Ngosa Simbiakula with 62 others. Our response as Laz: this matter has already clearly been settled by the Constitution. Under Article 116 of the Constitution, cabinet ministers are appointed from members of Parliament. It follows naturally that once Parliament is dissolved 90 days before general elections under Article 81(3), Cabinet is also dissolved. There is therefore no danger whatsoever that cabinet ministers can illegally stay in office. Nothing will be cured by the proposed amendment. Number 10, removing the limit for office of mayor. Under Article 152(b), the minister indicated, it is provided that the mayor and council chairperson shall hold office for 2 terms. Yet this does not apply to the office of councillor and member of parliament. It is proposed that Article 154(2)(b) be amended so as to remove the two-term limit for the office of mayor, to remove the discriminatory connotation and ensure consistency in the tenure of constitutional officers. Laz's response. This, again, is a reincarnation of Bill 10 of 2019. The proposal requires wider consultations and consensus with stakeholders. Maybe as a nation, as we deal with issue of limiting terms, the broader discussion should be whether this current limitation applicable to mayors and the Republican presidents should also not only apply to other offices, such as the office of members of parliament. It must therefore not be treated as a non-contentious issue that can be rushed, but one which must benefit from a holistic reform of the Constitution. Number 11 is a revision of the qualification of the office of Secretary to the Cabinet. The proposal is that the qualification for the office of Secretary to the Cabinet be reduced to 5 years instead of 10 years. That is indicated in the Constitution as experience required and as a member, as a parliamentary secretary or equivalent rank for the Secretary to the Cabinet. Our response as Laz is that it is difficult to appreciate the justification for the proposal. It is hard to make a case for the reduction from the current 10 years experience as permanent secretary for this critical role, which serves as head of the civil service and chief advisor to the president on the management of public service in line with Article 176 of the Constitution. We also note that 10 years is consistent with qualifications for other constitutional offices, such as High Court Judge, Director of Public Prosecutions, Attorney General, and Solicitor General, among others. We do not believe that there is any agency in any event in dealing with the proposal, considering that Article 61 or Clause 61 of Bill 10 had touched on this office before. Yet again, it must be part of the holistic reform of the Constitution. Number 12, revision of the provisions relating to the vacancy in the office of the Attorney General and Solicitor General. The proposal is that considering that under Article 176(1)(b) and 179(b), the offices of Attorney General and Solicitor General become vacant when another person assumes the office of President. It has been noted that this creates a vacuum whenever a new president assumes office, which grinds the operations of the offices. It is proposed, according to government, therefore, that Article 178(1)(b) and 179(4) be amended to provide that the Attorney General and Solicitor General are to continue holding office until formal appointment of new office bearers. Our response: the proposal is welcome to deal with the noted administrative vacuum created by the current constitutional provision. However, we do not believe that the problem can justify a piecemeal amendment to the Constitution, especially that this matter was also subject of Bill 10 of 2019. It must be treated like all other parts of the Constitution that require any reform. It must be part of the holistic reform agenda of government. Number 13, similarly, proposes the revisions of definition of child and adult under Article 266 of the Constitution. It has been observed, according to the Minister, that Article 266 lacks clarity because it deems a child as any person who has attained the age of 18 years. It is proposed that the word child be amended to provide for clarity. Our response as Laz is that this proposal is welcome to harmonize the definition of a child and adult. However, the challenge presented by this interpretation has largely been addressed by the Children's Code Act number 12 of 2022. It should therefore be part of the holistic reform agenda of government. Number B, or the other issue we want to comment on, is the proposed roadmap that government has given. And according to the proposed roadmap for the enactment of the Constitution, it is anticipated that by 25th of July 2025, the bill amending the Constitution would have reached the third reading in the National Assembly. There are many other steps that have been indicated there, including publication of the Constitution of Zambia Amendment Bill 2025 in the Gazette for 30 days for public consultation in accordance with Article 79 of the Constitution. Our response to the proposed roadmap is that while the roadmap is welcome, and Laz is on record that as soon as the new government, as the UPND formed government, we called on government to present a roadmap to help stakeholders and citizens to position themselves to support the process better. So we welcome that publication of the proposed roadmap. However, the roadmap is not realistic for purposes of dealing with the much needed wider consultations on some of the proposed amendments, such as delimitation and phasing out of by-elections. We also note that the roadmap was not delivered with the consensus, was not drafted with the consensus of key stakeholders. Rather, it is a unilateral gift from the government to the citizens. We don't think a roadmap for a critical reform of the Constitution must be developed only by government. The process must allow for all stakeholders to input on this proposed roadmap. Another problem is that this roadmap only deals with one aspect, the so-called non-contentious provisions of the Constitution. There is no picture about what about those that are not non-contentious, defined by whoever is making the definition. There's also no roadmap regarding amendments that will touch on the Bill of Rights. We do not think that this is sufficient. It is therefore clear from our end that the proposed reform process by government is a reintroduction of the infamous Bill 10 of 2019, which was opposed by stakeholders, including the UPND, while in opposition, and ultimately defeated by citizens. No substantive reasons why what was rejected in 2019 should now be supported. In any event, there isn't much which is substantially new to call for a rushed amendment of the Constitution. The country has lived on without Bill 10 and surely can also do so even now. The proposal to increase the nominated members of Parliament through an Act of Parliament is retrogressive and very dangerous for our democracy because of its potential to water down the accountability and legislative function of the National Assembly. In these circumstances, Laz calls on government to reconsider its plans to amend the Constitution in a piecemeal manner and so close to the electoral cycle. What we believe as Laz is needed is a holistic reform of the Constitution to include an expansion of the Bill of Rights to cater for economic and social rights of citizens. The constitutional reform must also be based on broad-based stakeholder consultations, both on the reform process and on the substance. I thank you. Unless there are burning questions, I don't see any on the floor. Any takers, one or two, before we call it a day? Okay, so we can take one.
So basically, I'd like to find out from you as the Law Association of Zambia, are you going to participate in the project status report and position, which is starting today?
Say that again. Say that again. Sorry, I didn't get the question.
So I'm saying that the opposition and the civil society movement, they are called for protest and they are starting today. They are saying that their members would be crowded in Black Attire and they'll be walking around stretching. So, as the Law Association of Zambia, are you going to participate in this process as part of showing this project what is proposed by the government?
Okay, that's a very good question, Barnabas. We have not taken a position yet. We will study the matter, but we believe government must be engaged, persuaded on the reasons why it is ill-timed to engage in the piecemeal reform of a critical piece of legislation as the Constitution. I'm also reminded when I was making some consultation, someone made a remark that what government has proposed is actually Bill 10 Pro Max. That's what they call it. So I said, what is Pro Max? So I was given to understand that it is a presentation of the same thing, but maybe with even more dangerous provisions. So I think as a country, we must be asking ourselves, do we need a Bill 10 Pro Max now, so close to the elections? Perhaps not. And there's a quote that someone sent to me, I think it was by the president, as he then was in opposition, that in as much as there may be one or two progressive provisions in the current amendment process, maybe we must heed his call that it is dangerous for the country to support the process, because it may be like drinking poison merely because there are traces of sugar in it. I thank you. Very, very last. Darius.
Just want to find out to what extent Laz on this government to stop this amendment process. I'm asking this from my own observation. This government is open to have the constitutional amendment.
Well, I mean, we must, first of all, as Laz, we have always asked government to talk about constitutional reform. You are unfair to citizens, one, when you don't present a roadmap. You're also unfair to citizens when you don't tell them which provisions you are talking about. And government has listened by providing first a roadmap as well as a timeline or an outline of what they believe are non-consultations. I think we are now in the process of engaging, and government on numerous occasions has demonstrated. I think there are some bills that were presented in Parliament. When there was a public outcry, government demonstrated by reversing, we are still very hopeful that this process will result in government reconsidering its position and not, as you say, be hell-bent to go with it, even when the merits do not outweigh the demerits of the process. Constitutions are not for governments. Governments come and go. Constitutions are for you and me, citizens of this country. We must be interested in its provision because we may be lucky to have a reasonable government in one era. The example of the provision that would allow nominated MPs to come through Parliament, meaning the limit be provided for under an Act of Parliament, can be abused by a bad president. How? Nothing stops Parliament from providing that, in fact, we want twice as many nominated MPs as elected ones. What are we creating for the nation? We'll be creating a monster that will haunt us. So let's all be participative. Let's take interest. It's yours and mine as a constitution. It's not for government alone. So government must play a facilitative role and not bulldoze the process. That way, we create pieces of legislation that help us to deal with the problems we are currently facing as a nation, including economic development. So I think government has demonstrated before that it is willing to hear voices from other stakeholders. We as Laz are still hopeful that government will take advantage of that window and reconsider the proposed amendment. I thank you and have a pleasant day.